Good afternoon, everyone. Welcome to this month's Employee Benefits Compliance webinar. As we are kicking off here today, you will see two polling questions appear on your screen. If you were with us last month, you may recall that our polls explored inequities in employee benefits, and we are further exploring that topic today. Our first set of polling questions focuses on the lower paid employees in your organization. Please take a moment and provide your responses as we get started. And as you're doing so, I'd again like to welcome you to today's webinar. I am Jenny Bedeau with Assurex Global, and today we will be hearing from Loomlight on leaves of absence and paid family and medical leave laws. We know this is a very, very hot topic. We have a lot of folks joining today, which is great. And we would like to extend a special thank you to your local benefits advisors and consultants who are partners of Assurex Global for making this webinar series possible. And we do welcome your questions during the presentation. You can submit those over using that Q&A function towards the bottom of your screen. We will address as many as time allows, but we know a lot of these questions can get really specific, so we are going to try and focus on those that are more broadly applicable. So if you do have a more specific question, please do follow up with that benefits advisor who invited you here today, and they'll be able to assist you. If you're just joining us, you'll see two polling questions up on your screen. Please take a moment and provide your responses. And I will also remind you, we do record these sessions. If you are looking for a link to the recording following this webinar, you can find that from the benefits advisor who invited you here today. They will also be able to provide you with a link to the PowerPoint presentation slides, but I will also drop a link to those slides in our chat section here in just a couple of moments. And we'll leave the poll up here for just another few seconds as a few more responses are coming in. So we can capture as many responses as possible. And do note, I have a couple of related polling questions during our last couple of minutes together, so please stick around to the end for those. Your responses really help inform our monthly market check surveys and really provide some valuable benchmarking insights. So I really appreciate your responses here. All right, so I will close out this poll and I'll share that out with everyone, and then we will move into our content. So it looks like about half of you, well, excuse me, exactly half of you are saying you're always evaluating the impact on lower paid employees when you're making those plan design or contribution decisions. And when we're looking at what aspect of benefit costs is most challenging for your lower paid employees, we're seeing most of you are saying it's those payroll contributions, really that costs coming right out of their paycheck. So again, appreciate your responses to those polls, and stick around for two more at the end. But for now, we will get moving into today's content. Joining us today from the Loomlight team is David Flaughton, Senior Consultant. David, I will turn it over to you.
Thank you. Hey, welcome everybody. Today we're going to cover leaves of absence. We're going to kind of do this in two pieces. My opening part here, we're going to talk about our general approach to how you handle benefits continuation during leaves of absence in general. And we'll use the FMLA in particular then as kind of a means of illustrating how that works. Then I'm going to turn and we're going to more specifically start spend some time talking about specifically state paid family medical leave laws, since those continue to proliferate, and they can be very challenging sometimes to implement. How do they work with FMLA? How do they work with my short-term disability policy, for example? So we'll spend a little time, the back half then of our seminar, talking about those laws. Obviously, by their very nature, each state's law is different. We can talk somewhat big picture as to commonalities, but just recognize we're not going to be able to get into depth of how the Colorado family leave works. That's just not going to happen. Okay. So let's start with this big picture question of leaves of absence and benefits. And I spend my day answering benefit compliance questions, mostly by email. And I'm not exaggerating when I say something like 40% of those emails are some variation of this question. We have an employee out on leave. They may have just gone out. They may have exhausted FMLA. It may be work comp. It may be PFML, but they're out on leave. What do we do with their benefits? How long can they keep those benefits while they are out on leave? So that is by far the most common question that I answer, or some variation thereof, because if you think about it, that one question is actually about 6 different questions. Okay. There's a fundamental question of how long can the employee maintain benefits before they're canceled. And we offer COBRA, assuming it's a COBRA continuable benefit. Uh, but that is it all benefits? Is it some benefits? Can the employee choose, even if they can continue? Could they also choose not to continue? So, but again, that's just the basic question of what can they continue. We then get into all the stuff that goes with that. How much do they have to pay for it while they're out on leave? If they're going to pay for it, what do the premiums do? What methods of payment are acceptable? Check, Venmo, where does the money get sent? What happens if the employee doesn't pay those premium payments? And then what happens at the end of the leave, assuming the benefits get canceled during the leave, what happens when they come back? Okay. So really that one question encompasses all of these. And like I said, I'm going to use the FMLA to kind of illustrate how you can answer those questions before we move on to things that are maybe not legally protected. Okay. So when we get this question, we take kind of a three-step approach, and we start by asking this question: is the leave of absence legally protected? Okay. The answer is yes, and we have to ask, okay, what does the law say then about the benefits? Second step, if the law is not, or if the leave is not legally protected or the law doesn't address the issue, the second place we're going to look is the plan documents. And do they address eligibility during the leave? And then the third thing we're going to look at, if the plan documents don't resolve the issue, is the employer's own leave policy. What does that have to say about benefits during leave? So I kind of break this down if you want to think about it. Step one is, what is the law of the land? Step two, what is the law of the plan? And step three is, what's the employer's law? And we're going to attack it in that order. Okay? So let's start with an assumption where we're going to go with that this leave is legally protected. And what do we mean by that? It's any leave of absence where there is a law that provides some sort of protection to the employee. Now, those protections may be job protections, they may be benefit protections. There are other things they may provide, but not every protected leave necessarily includes benefit protections. The three main ones are going to be Family Medical Leave Act, FMLA. USERA provides some benefit protections, that's military leave. And then most of the state leave laws and paid family medical leave laws will also have benefit protections built into them, but again, not universally. There are other forms of protected leave, things like a reasonable accommodation under the ADA or a reasonable accommodation under the Pregnant Worker Fairness Act, that are protected in the sense that you can't necessarily fire somebody while taking leave, or work comp, where you might be able to fire them, but it's usually not a good idea. And so we're usually going to end up extending their leave. But those laws don't necessarily contain specific benefit protections. But what they do say, and this becomes important when we get to steps 2 and 3, is that you can't treat employees on these types of protected leave worse than somebody on another form of leave. Okay. So work comp is a great example. When we get asked, this person's on work comp, we've been carrying their benefits, when can we cancel it? The work comp law itself most likely doesn't say anything. What it says is treat them the same. And so the answer to when can I cancel somebody's work comp or benefits while they're on work comp is at the same time as you would cancel them for an employee on any other medical leave. Okay. So let's start with FMLA. Like I said, I'm going to use this as a way of illustrating how to answer those 6 questions as to what happens to benefits during the leave. So first of all, get on my little soapbox. Don't call something FMLA that isn't FMLA. Okay. FMLA means specifically leave taken under the Federal Family Medical Leave Act. Okay. If it's something else, call it a medical leave, a family leave, a PFML leave, whatever. There is a tendency amongst benefit professionals and HR professionals, actually more benefit professionals to be perfectly honest, to label any sort of leave where it's vaguely got a medical or family connection, they just automatically call it FMLA leave. And if you do that, you're going to get a bad answer. And I've had that happen where they say it's FMLA leave and we answer under FMLA, 6 emails in, they're going, oh, wait, this employer only has 40 employees. Well, ignore everything I just said because all of it's wrong. So it's only FMLA leave if all 4 of these conditions are satisfied. The employer is large enough to be covered by FMLA, that's 50 or more employees. The employee is FMLA eligible, that's 12 months of service, 1,250 hours of service in the last 12 months, and working at a location with 50 employees in a 75-mile radius. The employee is taking leave for a reason that qualifies as FMLA, and the employee actually has some of their 12 weeks of FMLA leave time available. Okay? Unless all of those things are true, this is not FMLA leave, it's something else. But let's assume it really is FMLA leave. The FMLA then does have certain benefit protections built in. And specifically what it says is the employer has to continue all health plans, and that includes major medical, dental, vision, health flex spending accounts, HRAs, drug plans, fertility benefits, anything like that that's medically related. The employee has the right to continue those on the same terms and conditions as if they were still actively working. Now, alternatively, the employee, while they can continue those benefits, doesn't have to. They are allowed to turn them off, and that's at their discretion. Now, the non-health benefits, things like disability, life insurance, pet insurance, all that fun stuff, that stuff can be terminated during FMLA leave, but honestly, a lot of employers don't bother because usually they're the smaller ticket items and it's a lot of hassle. But just be aware of the non-health benefits you can shut off during the FMLA leave. So there's question 1, right? Which benefits can be continued? Can the employee choose to do something different? This also answers the question of how much does the employee pay, because same terms and conditions means the employee can only be required to pay their normal active employee rate in order to maintain that health coverage. Okay. So, assuming there's an employee contribution to maintain the coverage, the next question, of course, becomes, well, how do we get that money? Well, if the employee is using PTO during their FMLA leave or vacation or some other, parental leave that runs through your payroll, then you just do the normal pre-tax deductions. You just keep doing what you've been doing, even though they're out on leave. It's really only an issue when the employee is no longer getting paid through payroll, either because it's truly an unpaid leave or they're getting income replacement benefits from work comp or short-term disability or PFML, as the case may be. So you have nothing to take a deduction from. And in that situation, the FMLA gives you 3 options. You can have the employee prepay the premiums before they go out on leave. That has the advantage of you still get to do pre-tax deductions. The problem is, of course, you have to know far enough in advance the leave is coming to be able to plan that out and have time to set everything up. And the other thing the FMLA is very, very clear is you cannot mandate prepayment. You can offer it as an option, but you can't require it. Second option is do pay as you go. In other words, the employee is going to either write you a literal or proverbial check for the premiums during the leave itself. And then the third option is you cover the premiums during the leave and the employee gives you catch-up payments that you deduct from their check when they return to work. The advantage again being now we're back to pre-tax deductions again if we do catch-up. The risk, of course, is the employee doesn't come back and it becomes difficult to recover that. I'm not going to say impossible, but it is not easy to recover it if the employee just doesn't return to work at all. Now, as far as beyond kind of those 3 basic options, the details of it are largely left up to the employer. Okay, you can decide what the pay-as-you-go payment schedule is going to be? Is it going to be once a month following your COBRA schedule? Is it going to be your normal payroll cycle? So they have to write a check for you at the same time it'd be deducted from their paycheck. You can decide the rate of catch-up payments if you're doing catch-up contributions. You can decide what forms of payment are acceptable. You can decide other logistics. Where does the check have to be sent? Uh, so those details you kind of have to work out on your own and then communicate them, right? You can't expect the employee to follow a payment schedule if they don't know what the payment schedule is, or pay a premium if they don't know how to pay the premium. So ideally, the payment procedures should be described in your FMLA policy, or at a bare minimum, they're going to have to be communicated to the employee at the start of the leave. Now, unfortunately, the standard DOL FMLA forms don't have, there is a box to check to say you owe us premiums, contact us for information. There's not really good space on there to describe the process. So it may need that it needs a separate cover letter that kind of says, okay, here's how you go about paying your premiums, or a memo or something. Right? But it's got to be communicated somehow. Okay, so we got how much to pay, payment schedules, logistics. Next question is what happens if they don't pay, right? In the FMLA, if you're doing pay as you go, it does say you can cancel the coverage for non-payment of premiums, but there's two hoops you got to jump through. First of all, you've got to give a 30-day grace period. So if the premiums are due on the next payday, which is tomorrow, 5/22, the payment's not late until 30 days later on 6/21. In addition, at least 15 days before you actually cancel the coverage, you have to give the employee a written notice that says your coverage is going to be canceled on this date, going back to the last day you paid premiums, if you do not pay by the end of the grace period or the 15-day warning period, whichever is later. So you have to do both of those things. The grace period is usually not the problem. By the time you're sending me the question, we're usually way past 30 days. It's the second part that's the problem. People don't realize they have to do this 15-day warning letter before they can actually cancel the coverage. Doesn't mean you can't cancel it, just means you have to do the warning letter now and then wait 15 days. So last thing then is, okay, what happens at the end of the 12-week leave? Well, first of all, if the coverage continued throughout the old time period, nothing changes, so it just keeps going. It's really a question of what happens if the coverage cancels during the leave and whether the employee returns or not. Now, if the employee does return within the 12 weeks of FMLA leave, then any canceled coverage, whether because the employee dropped it voluntarily or because of non-payment, does have to be restored immediately upon return to work with no waiting period. If the employee doesn't return within the 12 weeks, first of all, there is this goofy rule under the FMLA that says if they don't come back at the end of the 12 weeks, you have to offer them COBRA at that point, even if the coverage has already been canceled, which makes absolutely no sense, but that's the rule. The bigger question is, what if the coverage didn't cancel? They maintain the coverage, they paid their share, we get to the end of the 12 weeks and the employee needs more time, and you decide you're going to grant them more time. Do I have to COBRA them at this point? And the answer is not necessarily. We get into your non-FMLA leave policy, which we're going to talk about here in just a second. So that's the question. If we get to the end of the 12 weeks and the employee doesn't come back, you can COBRA them at that point. But whether or not you actually have to is going to depend on your plan documents and your own leave policy. Now, before we move on, let me see, I know I have a few questions here. Let me see if there's any I can grab real close. If an employer is across multiple states, so some states have more than 50 employees and some states have less, Can we treat all employees like we have more than 50 employees when it comes to offering FMLA? And this is getting to that eligibility requirement that says there have to be 50 employees in a 75-mile radius. So I'm assuming what the person is saying is none of our locations have 50 employees in a 75-mile radius. So technically, nobody is eligible for FMLA. You absolutely can grant FMLA-like benefits, but it is not FMLA. Okay. Don't call it FMLA when it isn't, because it can lead you again down the wrong path. Maybe today nobody's FMLA eligible, but 3 weeks from now you suddenly have a hiring burst in one of your locations and it goes above 50 employees. Those people are now FMLA eligible, but none of the leave they took prior to that was FMLA leave. So they've got a fresh 12 weeks of leave available. So again, don't call it FMLA unless it really is FMLA. Call it FMLA like or the XYZ company FMLA benefit, something like that. Aren't there rules that state you can't cancel someone's health insurance retroactively? There are indeed. That is very good. Generally speaking, you can't cancel coverage retroactively, with one of the major exceptions being you can cancel retroactively for failure to pay premiums, which is, of course, exactly what we're talking about here. If they don't pay their share of the premium during FMLA leave, that is an exception. You can, in fact, cancel retroactively. Whether the insurance company will let you do that's a different question. But yeah, no, you can do it when it's non-payment. Restoring benefits immediately. Does that mean return to work 5/22 and effective 5/22 or 6/1 when administratively possible? It means 5/22. It's immediate. There is no grace period in there, which means you may have to argue with your insurance company who doesn't want to do it till 6/1. And you're going to have to tell them, I'm sorry, this is FMLA leave. It gets reinstated immediately. All right. And there's various variations on the theme, and some of these are actually going to come up here in just a second. So why don't we move on to that? So what happens if it's not the legally protected leave, or we've exhausted the legally protected leave? The employee has used their 12 weeks of FMLA and they're not coming back. And I don't mean they're not coming back in the sense their employment is ending. I mean they need more leave time. All right. So the second place we look, if there's no legal protection for this leave, and that again could be because they're not eligible for FMLA leave yet. It could be because the reason they're taking leave is not qualified. For whatever reason, there's no law that applies here. The next place we're going to look is in the plan documents. Now, some plan documents will very specifically say this is how long an employee can remain on leave and still keep this benefit. Most of them do not. Most of them are very vague or just silent. They may address FMLA and USERRA, but that's it. Some of them are just explicit and say, go talk to your employer about benefits during leave, and just kick it back to the employer. But you have to check, because if the plan documents do in fact have a specific rule, you have to follow that rule. Because if you don't, you're running the risk of claims being denied. And I can tell you horror stories. One of the places we see this most often is life insurance disability AD&D policies. Will very often have very short windows, and it will say very clearly this person can remain on leave for 2 months, after which their coverage is no longer valid. And I've had employers who, they have an employee with a terminal condition, they feel bad for them and their family. Their leave extends beyond FMLA and it goes to 4, 5, 6 months. They don't cancel the life insurance. The employee dies, and the insurance company says you left them on too long. We're not paying, which is not a conversation you want to have with a grieving family. So you do need to know what all of the documents say. They may not all say the same thing, so you have to look at every single one of them. Don't forget to look at wrap documents. That's a place where we will often see language on leaves of absence. And again, if there is a plan document that does specifically say, here's what happens for a non-FMLA or a non-protected leave, you need to follow that language. Now, typically the plan document is only going to answer question 1, how long can they keep this? You're then going to still have to answer all the questions about how much they have to pay, how are they going to pay, what happens if they don't pay. Um, it's purely a question of how long they can keep it. And I wish I could tell you every single plan document had a nice, neat section that said, here's leaves of absence. And unfortunately, it's not that simple. It can be in any number of different places. It could be in the eligibility section. It could be in the section that talks about when coverage ends. I've seen it in definitions. It might be in the COBRA section. It might be in a section called leave of absence, and then again, it might not. I've looked at any number of documents where there is a leave of absence section. I'm like, oh, great. And then it doesn't address, it only addresses FMLA leave. Okay. So you do have to look, we love searchable PDFs. It makes it way easier to try and look and see if there is anything about leaves in there, but it can be in a variety of different places. So I put this up here just to kind of illustrate the point. So these are from real actual plan documents. On the left-hand side is from a standard life insurance contract, and the right-hand side is a UHC health plan. Okay. The life insurance contract is typical legalese mumbo jumbo that keeps pointing you back and forth. But the gist of it is if you read this section about when life insurance ends, it talks about there is a leave of absence section here. And it says during any other scheduled leave of absence approved by your employer in advance and in writing, lasting not more than the period shown in the coverage features. So you go back up to the coverage features, and sure enough, here's this thing. This is leave of absence period 60 days. So what this is saying is that for a non-protected leave, the life insurance can remain intact for 60 days, but after that, you have to cancel it. Okay? You cannot just leave the employee on. Whereas the UHC language is kind of vague. It doesn't really tell you much. And I know several of you are going, well, wait a minute. No, it says they have to work at least 30 hours a week. Uh-huh. And when an employee goes on vacation and works 0 hours a week, do you take away their health insurance? No, of course you don't. What if work is slow and they're only doing 20 hours a week for the next 3 weeks, but then it goes back up again? Do you take away their health insurance? No, you don't. You don't literally mean 30 hours a week when you read that. And so that's why I say this is actually ambiguous. It doesn't really tell us how long a person can be out on leave not working before they're no longer scheduled, and that's the key word here, scheduled to work 30 hours a week. So that contract doesn't actually answer the question for us as much as we'd like it to, which leads to step 3. If the plan docs don't answer the question, it's going to come down to your own leave of absence policy. Okay. There's no bright lines here. You have some flexibility to decide how long an employee on a non-FMLA leave can maintain their coverage before it's going to be canceled in COBRA. The main thing is to pick a time period and then stick to it and be consistent. You can have different time periods for different types of leave. Most employers are going to be more generous with medical leave than personal leave, for example. That's okay. What we don't want is the employer, this open-ended, vague, wishy-washy policy that says, well, we'll decide how long maybe you can stay on. It should be a bright, hard line stop. You can keep it for this long and then you're COBRA'd. And that might be 0 days. It might be as soon as FMLA leave ends, you are COBRA'd and we're done. But it doesn't have to be. Again, it can be another 30 days, 60 days, 90 days. I wouldn't go 2 years. But the point is to have a rule and to be consistent about it. I really don't recommend kind of these open-ended, wishy-washy, non-specific policies, particularly if you have a self-funded health plan. If you have a self-funded health plan and somebody hits the stop-loss deductible limit, stop-loss is going to start asking you a whole bunch of questions about why this person is not working and yet they're still on the plan. Now, in my experience, if you have a clear leave policy that says they can keep their benefits for 6 months and on FMLA leave, most stop-loss carriers will honor that. If they get back a policy that says we reserve the right to extend leave and may continue the coverage during that time, they're going to say, okay, you don't have a policy. We're not reimbursing you. So it is important to have a definite date in there. Beyond that, think about the larger leave policy. How long do you normally extend leaves for beyond FMLA? If it's only 30 days, well, maybe just extend the leave benefits another 30 days. If you go 6 months, maybe you don't extend benefits all 6 months. If you're an applicable large employer under the ACA, that's going to influence your decision. Okay, because if you're using look back measurement to determine full-time status, an employee on a leave of absence is still ACA full-time and can still trigger a penalty. Does that mean you have to continue the coverage? No. You just have to recognize if you're going to COBRA them because of their leave, they are a penalty risk. And that's a factor in your decision. Then obviously we got corporate culture, employee relations, and yes, money. It is going to cost more to leave somebody on the plan, particularly if it's a medical leave, right? The reason they're out is there's something medically wrong, which means they're probably using the health insurance, which is probably costing you money. That is a relevant factor to decide when or consider when you're setting what your leave policy is going to be. And so ideally, then your policy addresses all 6 of those questions. So you're not left guessing. Or when you email me and say, how long do they stay on and when do they have to pay? My answer is, I don't know. What does your policy say? Because there's no other source of information, right? If we've gone through, the law doesn't apply, the plan docs don't address it, there's nobody else who can answer those questions at this point but you. Now, with respect to COBRA, if the person gets to the end of the period where you're willing to maintain the coverage and you cancel it, that is a COBRA event. It's a COBRA event due to reduction in hours. Even if you don't terminate their employment, it's a COBRA event due to reduction in hours. You have to offer COBRA. Okay. If you're canceling the coverage for non-payment of premiums, though, that is not a COBRA event. Okay. So do not, if that's what's going on, if you're going to cancel the coverage, whether for FMLA or non-FMLA, if you're canceling it because they didn't pay the premiums, they do not send out a COBRA election notice at that point. And lastly, restoration of benefits. Again, this is a plan design question. I can't tell you, we get asked what happens when they return. Can they get back on right away? Is it first of the month? Do they have to go through the waiting period? You can write your plan and your policies to do any of those things. There is no one size fits all answer if it's not a legally protected leave, which is why it needs to be addressed either in the plan documents themselves, and if it's not, in your leave policy. Ideally, do this up front. Set your policies, answer all these questions before you've got people out on leave. If you come to me and somebody's already on leave and you say, we don't have a policy, my answer is going to be, well, it's time to draft one. But then you've got the additional question, can I impose this new policy on somebody who's already out? And if that's a work comp person, that's really awkward and potentially even runs a liability risk. So try to avoid getting caught in that situation and deal with this up front. And then document it, whether that's in the employee handbook, wrap document, even if it's in HR standard operating procedure, just so that it's somewhere that there's a clear-cut policy. Because what happens if you don't? You have an increased risk of discrimination and retaliation claims, increased costs because you're leaving people on the plan longer than you need to. You're potentially extending the COBRA period out. And of course, our biggest fear is that the insurance company or the stop loss carrier starts saying, well, you shouldn't have left them on, and we're either not going to pay the employee or we're not going to pay you, the employer. Okay. So have a clear policy, address all the issues, follow it consistently. All right, we're going to move on to PFML. Let me just skim through the questions. We do have a lot of questions, and I do apologize. There's no way I'm going to be able to get to all of these. So a lot of these are variations on exactly the question I get. They've been on leave. They're not FMLA eligible. They've been out for 3 months. We've just kind of left her on there. How long do we keep them on? What does your policy say? Again, nobody else can answer that question but you. Here's a good one. After the 12 weeks of FMLA are done, or just for non-FMLA leave in general, can the employer just say, we're going to quit paying our share of the premiums and you, the employer, are responsible for 100% of the premiums? Okay. And I'm assuming underlying this question is, but we don't want to do COBRA. If you're going to charge 100% of the premium to the employee on leave, do COBRA. Just COBRA them. We know the rules. We have a preordained process for how that works. There's no difference functionally between the two in terms of how much has to be paid. If you don't COBRA them, one, you're just delaying the COBRA process. And two, it's actually ambiguous. Is this person not on COBRA because you forgot to issue the COBRA paperwork? Or is there something else going on? If you're going to charge 100% of the premium, my advice is just COBRA them at that point and be done with it. What if we're doing catch-up payments and they don't return? Can we retro cancel their benefits for non-payment? You can, but you have to follow that 30-day grace period and 15-day warning before you do that. Okay. And if you think about it, what's the due date on catch-up payments? It's when they return or would have returned. So it's possible, but this is why I say it gets very difficult when you do catch up and the person doesn't come back. To actually satisfy all those rules and get your money back is not an easy thing to do. So that is, I'm not saying don't ever do catch up, but just as the practical reality is you have to accept the risk. You're not going to get repaid. Okay. All right. Need to move on. So let's start talking about PFML and state leave laws. And obviously, this is just a specific version of step one of the analysis, which is their legally protected leave. It's just a different type of protected leave coming from state law rather than federal law. Now, unfortunately, again, we've got 50 different states plus the District of Columbia, plus territories if you've got outfits in Puerto Rico, all with their own rules. Okay. Now you can find benefit. Some states have unpaid leave laws that have benefit protections built into them, like Wisconsin. The states with paid family leave laws, most of them have benefit protection built into them, but not universally. It does vary significantly. So unfortunately, the answer is for those of you, particularly if you're in multiple states, you need to find a good resource for the states where you have employees to figure out the details of what works and how things function in that particular state. I can only talk high level. I can't necessarily give you, unless we're dealing one-on-one with a question, I can't tell you, this is specifically how this works in California versus Nebraska. Now, when we talk state leave laws, we're actually kind of talking three major categories here. Historically, most state leave laws were unpaid leave. They were basically mini versions of the FMLA that promise an employee time off with job protection and possibly benefit protection for some period of time for reasons that were often very similar to FMLA. There's still plenty of those out there that exist. But that's one category. It's kind of those unpaid leaves. Think of it like a state version of FMLA. Then we started seeing a proliferation of sick and safety time laws, or SSTs. These are analogous to vacation, or not some more commonly sick leave, and they mandated that the employers provide a certain amount of sick leave. Now, these laws typically don't have benefit protections built into them because they're intended to cover short periods of illness and injury, not long-term leaves of absence, okay? And there's some of these at the state level, there's some down at the local level, but again, they're different from really the unpaid leave and the paid family medical leave laws, because then the PFML, this is more analogous to short-term disability or paid parental leave, where it's a state program that will actually pay compensation for an employee out on leave, an extended leave, for certain specific reasons. And that kind of comes with it comes the fact that, well, it's a leave, but the main primary feature of it is that it is paid. that the employee can actually take the time off and receive some compensation to make it easier to deal with family obligations and medical issues and the like. Now, any given state can have one, two, or all three types of leave laws. Okay. And so you've got to know in the states in which you have employees, which type of law do they have and what are the requirements of that particular law in that state. I'm going to focus more on the paid family medical leave, but just be aware these other types are out there. So currently there are 14 states plus the District of Columbia that either have or are in the process of implementing paid family medical leave. Maine and Minnesota just went into effect in 2026. Maryland is scheduled to start collecting premiums in 2027 and leave in 2028. There are always new proposals pending in a lot of the other states, so I think it's fair to assume this is likely to expand. How quickly, we'll see. Now, as far as, why can somebody take PFML? A lot of these do mirror the FMLA. It's for very similar reasons. The employee's own serious health condition, birth or adoption of a child, caring for a family member with a serious health condition. But there are some important differences, which we'll touch on here in a slide coming up. But one of the most important things, particularly if you're moving into a state with PFML for the first time, maybe where you operate doesn't have this and you're adding employees in a state that does. Probably the most important thing to recognize, PFML is not short-term disability. We get all the time, the employer says, well, I've got a short-term disability policy that covers everybody. Isn't that good enough? And the answer is no. Your existing short-term disability policy is almost certainly not going to satisfy your obligation under state PFML laws, and you are going to have to either pay into the state program or you're going to have to go buy a separate policy just to provide those PFML benefits. So do not assume that your existing STD policy is going to help you here. They're a good place to start. They might have a rider you can just tack onto it to get your PFML coverage, but don't just assume I've got STD and therefore I'm done. So I've listed out, these are the states that have paid family leave or disability / paid family leave. If you look on the right, you can see there's several that have a checkbox, just on its own. Those are what I call the legacy disability states. It's California, Hawaii, New Jersey, New York, Rhode Island. They had mandatory paid disability laws long before anybody else. And so what happened then as PFML became more prominent, the legacy states kept their existing disability provisions and then added on PFML provisions on top of it, other than Hawaii. Whereas the newer states that didn't historically have disability, they just adopted these global PFML policies. And in there, one of the reasons for leave is the employee's own disability. So there is a disability benefit built in. It's just part of the overall PFML program. Okay. So when does one of these laws apply to your employees? And the general rule is going to be it's the law of the state where the employee works that is going to control. It's not where you are headquartered. For my example, you've got a company headquartered in Oklahoma, which has no leave law. They have employees who work in California and Washington, both of which do have PFML laws. The employer is going to have to comply with California and Washington law for the employees in those states. Again, it is where the employee works, not where they live. This is particularly, we see this a lot on the East Coast, where people will very commonly live in one state and work in another. It's the state where they work that matters. And even the carriers get it wrong. We're just dealing with, I won't name names. We're dealing with a carrier who kept giving bad advice because they saw the employee's home address and said, well, you have to go apply for benefits in Delaware. Well, no, I work in Maryland. It's sending me to the wrong place. And it is a physical location of the work that counts. So this is particularly your remote employees. It doesn't matter that they're reporting to a boss in New Jersey or wherever. What matters is where are they physically doing their work? That is the state that is going to control. Now, there are some employees where this gets complicated. Think truck drivers, which may not really have a fixed location. There are rules about how to resolve that. For the vast majority of employees, it's just where are they working? That's the state's PFML law that you have to worry about. Now, unlike FMLA, which is limited to employers above a certain size and employees who meet certain eligibility criteria, which means you can have employers who are not subject to FMLA, or you can have employees who are not eligible for FMLA leave yet. That is far less common when we're talking about a PFML law. There are exceptions, and we can't go into all the corner cases, but you should start with the assumption, unless somebody tells you otherwise, if you are an employer with employees in a PFML state, you are covered, and all of your employees are covered, whether they're full-time, part-time, just started, been there 10 years, work sporadically, on call, doesn't matter. As a general rule of thumb, all employers in a PFML state and all employees in that state are eligible for PFML leave. Now, depending on how big you are, you may or may not have to contribute to the PFML plan, but don't assume that, well, I only have one person in Colorado, so I don't have to worry about it. That is not true. Or I have this part-time employee who only works 10 hours a week, so they don't get PFML benefits. Again, usually not true. So that is one of the biggest differences between FMLA and PFML, is that it's available to a much broader range of people. It's also generally available, even though the reasons for leave are very similar to FMLA, it's often broader than FMLA. And a great example of that is most of these PFML laws will say you can take time off to care for a family member with a serious health condition, which is true for FMLA as well. Except under FMLA, the family member is either your spouse, your parent, or your child, and that's it. The state PFML laws often go beyond that and will go to grandparents, grandchildren, nieces, nephews, aunts, uncles, domestic partners, and their children. I've even seen, I think there's a couple of them that just say anybody you consider your immediate family. So it can get much broader than it does under federal law. Another one area where there's often a difference is that a lot of these state PFML laws apply for people dealing with domestic violence or sexual assault, and they need time off, whether that's to go to court, move into a shelter, attend counseling or therapy. Those things will be very often covered under PFML, whereas they may or may not be covered under FMLI. Now, PFML laws may or may not provide job protection or benefit protection. The newer ones, those non-legacy states, they almost all, I think it's fair to say all of them, the non-legacy states do have job protection built into them. And part of that job protection is benefit protection. Now, again, most of the time, the benefits we're talking about are health benefits. So much like FMLA, in theory, you could cancel the non-health benefits. The legacy ones may or may not have benefit protection. And I'll give you two examples just to show what a mess this can be. California has temporary disability, TDI, PFL, those are paid leave benefits. They do not include any job or income or benefit protection. However, California also has the California Family Rights Act, or the CFRA, which mirrors the FMLA, and that does have job protection and benefit protection built into it. So in California, there is benefit protection, but it doesn't come from the paid leave law. It comes from the CFRA. New Jersey is similar. They have a TDI benefit and a PFL benefit, purely income replacement, no benefit protection. However, they also have the New Jersey Family Leave Act, which does provide benefit protection. But significantly, the New Jersey Family Leave Act applies to birth of a child and caring for a family member. It does not apply to an employee's own disability. So an employee taking paid family leave for their own disability in New Jersey gets TDI benefits, but no benefit protection. But that same employee taking time off to care for a family member with a serious health condition gets both paid PFML benefits, plus they do get benefit protection. So what you have to break all these laws down into their own separate buckets and keep very close track of whether any given absence, which bucket or buckets is it falling into, and which of those buckets provide job protections and which do not. Now, there is a valid question here. If you're an ERISA employer, usually you do not have to follow state benefit laws, at least with respect to your ERISA plans. And so there is a question as to, are these state benefit protection laws that say you must maintain health insurance, are they preempted by ERISA? And there is actually a pretty good argument that they are. However, since in a lot of cases this is going to overlap with FMLA anyway, and you're going to have to keep the benefits going for that reason, a lot of employers just kind of just accept it, and they just follow the state benefit continuation provisions. It's just not worth the fight in a lot of cases. But if you really want to have that argument and are willing to take the state on and claim ERISA preemption, we don't have to maintain benefits when it's just PFML leave. There is at least a reasonable argument that that is correct. Okay, but let's put it this way: there's not like a body of case law out there, so you got to be willing to be a test case if you're going to do that. The PFML laws are usually a lot less detailed than the FMLA, which means they're probably at most going to tell you which benefits to continue and how much the employee can be charged or required to pay. They are not going to answer a lot of the other things about when premiums are due. Can you do pay as you go or catch up? They don't even, a lot of them don't even say you can cancel the coverage if they don't pay the premiums. It's kind of implied, but they don't come right out and say it. So very often for those logistical details, when it's PFML, you still have to provide the extra bits and pieces. Again, this is where your own leave policy becomes helpful. If the law doesn't answer the question, fall back on what your own leave policy says. Or alternatively, follow the FMLA rules. Either of those you should be okay if the state PFML law doesn't specifically address the matter. Now, these PFML benefits get funded in different ways, but broadly speaking, they fall into three buckets or three categories. First is payroll tax contributions. So you are either collecting payroll taxes from your employees, or you yourself as an employer are paying in payroll taxes, or both, that goes into a state program, and then when the employee needs benefits, they apply for benefits from the state program. This is a default mechanism in all states except for New York. In New York, you actually have to buy an insurance policy. There is no state program, but you're still obligated to buy the insurance policy, much like you're obligated to buy work comp policies. It's the same thing. So that's kind of the default, is you pay into the state program, and essentially it just becomes a tax, and the details of who gets paid and applications and all that fun stuff falls on the state. The other funding option is that you go out and buy a private insurance policy that covers your disability and PFL obligations. Again, in New York, that's your only option. You have to do that. Most of the other states give it as an alternative. You can either do payroll tax or you can purchase a private insurance policy. There are exceptions. For example, California and Washington do not have private insurance markets. You have to go through the state program. But most of the other states, you get a choice. And so far, what we've seen, the private insurance policies are way cheaper than paying into the state program. But there are some additional things that fall on you. You have to apply for permission in most states to do a private insurance policy. You've got to obviously make sure the premiums get paid. You're going to be the one interacting with the insurance company. Well, the employee will do most of it. But yeah, so in most states, that is an option. And then the third option, and I think every single state will let you do this, is you can self-fund the PFML benefit, but you have to apply for permission. And again, it's usually not worth it unless you're a very large employer. There's fees you got to pay. They want to make sure you're solvent. You may have to post a bond. You may have to. California's got an interesting requirement. Say you can self-fund, but the benefit has to be at least as good as the state plan plus one other thing. In other words, if you're going to self-fund, you got to give a better benefit than if you go through the state program. So very few people do the self-funding option, but it's there if it is something that you wanted to explore. Okay, last couple of things, and then we're going to be out of time here, is how does these PFML laws interact with other benefits? Starting with FMLA, now, if a given absence does qualify as both FMLA and PFML, they are going to run concurrently. The absence, the time off will count against both leave entitlements, and then you have to follow whichever law is most beneficial to the employee. Okay. Having said that, there are a lot of situations where the absence does not qualify as one or the other. It's only FMLA or it's only PFML. In which case the leave is still going to be protected and you have to follow the rules of the law that applies, but the time that the employee is taking is only counting against that one bucket of time. It is not counting against the other one. And the employee then retains the full amount of the other type of leave to use in the future. And I put up some examples just to illustrate various ways that that can come up. So for example, a part-time employee often will not qualify for FMLA, but they will qualify for PFML. So that employee can take their PFML leave and it's not going to count as FMLA leave. Now, as long as they remain part-time, that doesn't matter. But if that same employee goes to full-time in the future to the point they are now FMLA, they have a full 12 weeks of FMLA coming. None of that time they took as PFML counts against their FMLA bucket. Or you've got a full-time employee, but they're a new hire. Remember, you have to work 12 months to be eligible for FMLA leave. So they don't qualify for FMLA. They do qualify for PFML, so they take PFML. That is, again, not FMLA leave, which means that later on in the year, when the employee reaches their anniversary date and becomes FMLA eligible, a full 12 weeks of FMLA leave springs up. And again, the time they took as PFML won't count. Or it can come up because the employee takes leave for a reason that doesn't count as one or the other. So for example, the employee takes leave to care for a grandparent with a serious health condition. As I mentioned, that's not FMLA leave, but it very well could be PFML. So the employee can take that time off under PFML, claim the protections of state law, and they're still going to have 12 weeks of FMLA leave down the road to use for other FMLA qualifying reasons. Or it can go the other direction. Maybe an employee works in a state without PFML. They take 12 weeks of FMLA leave when a baby is born. They're then transferred to another state that does have PFML. And as soon as the employee earns enough, they apply for PFML benefits for that same child. And guess what? They get it. As long as it's within a year of the child being born, is usually the measurement. Again, the reason is because the time they took off before couldn't possibly have counted as PFML because they weren't in a state that had PFML. So even though, yes, these are going to run concurrently, just be aware there are lots of circumstances where they will not, and you have to track them separately. Last thing then, how does PFML interact with short-term disability? As we've already said, you can't count on your short-term disability policy to satisfy your obligations, but that doesn't mean you have to get rid of it. You can offer both. The question then is how do they interact? And unfortunately, the states are all over the map here. I'm gonna shorthand it here, which is basically say, check your STD policy. Usually it's the STD policy that's going to give in. And what I mean by that is reduce the amount of benefit if the employee is collecting both. There's a lot of STD policies that actually require that you apply for PFML as a condition of being able to collect short-term disability. So if you are moving into a state or adding employees in states with PFML, besides getting everything set up for your PFML program, also take the time to look at your STD policy and figure out how is this going to interact. In some cases, it makes sense to carve those PFML employees out of STD and say, we're just not doing this. You're going to rely on the state program. Other cases, it does make some sense to offer both. I had one person the other day who made the decision we're going to offer both. And then what they found was because of the way the offset worked, after the person collected their PFML, they were getting $20 a week from short-term disability, which was a lot of work for the HR person to be filling out all the paperwork to let them keep collecting $20 a week extra in benefits. They made the decision we're not doing this anymore, and they carved the Colorado people out of that short-term disability policy. All right. I know we have 1 minute to go. Oh, I think we just hit four. Jenny, did you want to do your polls?
You had a lot to cover, David. Thank you for covering everything. And as we close out here, I do have a couple of final polling questions. If you're with us at the top of the hour, you know that we covered some equity questions. We have two final equity questions. So please do take a moment and let us know your responses to these questions. We are curious if your organization conducts formal pay equity analyses, and also if you vary employer contributions based on your employee income or pay level. So as you are providing your responses, I will again thank you for attending today's webinar. We had a ton of questions come in. There was certainly no way David could address all of them, though he certainly did his very best. So if you still have any questions, if we weren't able to get to your question, please do connect with that benefits advisor who invited you here today. They can provide you with some further guidance. And a link to the recording of today's session will also be available from that benefits advisor. If you want to review this content again or share it with a colleague, your benefits advisor will be able to provide you with a link to that recording. I'll leave the poll up here for just a few more seconds to capture a few final responses. And a quick sneak peek would tell me that actually, I didn't know how that first question was going to land, how many pay equity analyses were happening, and we're actually seeing a fair amount. About half of you, a little more than half, are doing them at least some of the time. Um, but for that second question, we're seeing most of you are saying your contributions are the same for all employees. So I will share those out here in just a second. Okay, so you can see those results there. And again, we always appreciate you sharing your responses to these. And again, a full kind of write-up and analysis of these responses will be available in the form of what we call a market check survey that gets published within about a week of these live events. So keep an eye out for that from that same benefits advisor who invited you here today. But with that, that does conclude our time together. Thank you again for joining us. Thank you, David. Wishing you all a wonderful afternoon.